Hello, Milltown. My name is Ken Vercammen, and I'm an attorney in Edison, New Jersey. I lived 22 plus years in next door in South Brunswick off of Riva, so I would used to go to a lot of Milltown things, either the VFW or the Classy Golden Line. I got 30 minutes to talk about wills, powers of attorney, probate. My assistant, who's a go-getter college student, is timing us. So time us for 30 minutes, okay? And then you got to wave your hands. Actually 29, and that way I will stop. So a lot of times, though, people will say, whether or not I'm at the Elks Club or stopping in the My Legion. I goes, Kenny, why do I need to have a will? Doesn't everything automatically go to my spouse or my kids? He goes, oh, sometimes yes, it depends, but that's not really doing planning. That's just hoping that everything happens right down the road. So, for example, sometimes someone's married, but their spouse might not be the right person to be the executor, or they may not want to leave their assets to their spouse, not because they don't like their spouse, but their spouse is like, getting ready to go into assisted living or some other place, and why leave everything to that spouse to have it go to the government? If someone doesn't have a spouse, someone says, I got 3 kids. He goes, well, it's still, if you don't have a will, it makes it more difficult. That means all 3 kids got to agree upon who's going to be the administrator, and the people not going to be the administrator got to sign this renunciation. So 2 weeks ago was Christmas, and if you said at Christmas, listen, I want this person to be the in charge, everyone at the table is going to say, yeah, no problem, we all agree with you, Mom. No one's going to say, no, I don't. I want to screw Steve when down the road. But the problem, if it's not in writing, it's nothing. Even if everyone recorded it, it got to be in writing, properly signed. And the circuit's office, when they've done seminars with us, say the problems we see all the time is when people cheap out and try to do their own thing themselves on something they found online, and they don't sign it right or they don't do it right, and it says valid as a $3 bill. So it's better to have something done right. When I owned my first house in Edison, it was a wooden Cape Cod, and I was proud that I set up all the landlines in each room. And then goes, hey, let me try to do some of the electrical work. And I go, it shouldn't be that easy. I go to Rickles, and because I had to change the 2 prongs into the 3 prongs, and I almost burned the house down. So it's best to get a professional to. Now, and if there's no will, that means that the person who's the administrator has to take out what's called a surety bond. That's a couple more grand. But more importantly, you lose the opportunity to make sure that who you want to have your stuff, you lose. So, don't, get things done. So, believe it or not, New Jersey has kind of made it a little bit easier to get things done. Let's say so. Logistically, what we do is we email or mail someone for the seniors, a 1-page questionnaire. Who's it? What's your name? Are you married? Who's executor 1? Who's executor 2? Not that complicated. Now, we found emailing was easier. Some of the seniors will say, I'm not that good with email. I go, yeah, but you have a daughter or granddaughter that is. And what you can do is you can call that, especially when it's like a grandkid that lives like 2 towns over, you can say, listen, I need you to come over and help me with something for 45 minutes. And if they say, I'm too busy for the next 3 weeks to spend 45 minutes with you, they goes, hey, no problem, I'm going to give you $5,000. But I guess you're so rich that you don't need the money. Oh, no, I'll be over. So now you always want to have an executor 1 and executor 2. Even if there's 2 kids, you don't want them to be joint because it kind of that means that they have to do everything together. Do things twice. 2 people got to go to the circuit's office, 2 people got to sign every check, 2 people, I got to do it. It's better to have a number 1 and number 2. They could be twins living with each other, but again, why have to? And that's where people get along. I was involved with an estate where these 2 brothers, the dad decided to make them co-executives. They couldn't agree upon what color the sky was. Brother number one says the sky's blue. The other one says, no, it's gray. You're stupid. You've always been stupid. Here's the judge saying to these guys, fellas, why don't you guys go out at the lunch break and have a cup of coffee and talk about all the fun stuff you did with your parents when you're younger? Because you're just running up court fees and legal fees because, Dad did it this way. So, Executor 1 and Executor 2. Now, let's see. New Jersey, believe it or not, has reduced some of the taxes. There used to be, there used to be a New Jersey estate tax, and every penny over $6.75 was taxed. They did away with it. But there is a federal estate tax, but it only pertains to you people here that have more than $13 million. Is there anyone in Milltown that has more than $13 million?
Yeah, there are.
But the other thing is, lives.
They're not sitting here.
Yeah. Oh, I know. Tony Vignola's in Florida for the winter. His daughter is our presiding probate judge now. He's a Milltown guy, and I sometimes you say real Milltown, not like lives in whatever town with a Milltown mailing address. So we do ask though, what real estate do you have? Do you have real estate in any other states? And what's the approximate amount of everything else combined? Some people, I haven't gotten around to filling out the form. It goes, it's 1 page long. How complicated is that? Well, I'm trying to figure out all my account numbers. It goes, I didn't ask for any account numbers. I don't need it. It's not really my bit. I don't need to know. I just need to know kind of an approximate. Now, I'd say, and what do you have? So, and then who's your beneficiaries? And remember, for your beneficiaries, let's see, you decide who gets. The only in New Jersey, you can't leave a spouse penniless. Other than that, if someone says, I want to leave everything to the Yellow Dog Society, then that's your right. Last year, a client goes, do I have to treat all my kids equally? He goes, nah, you do whatever you want. To her about the dogs. And she goes, well, my one son lives on the West Coast. We don't hear from him much. Okay, well, did you get a card or call from him on Christmas, Mother's Day, or your birthday? No. I go, why would you leave anything to this bum? Because this guy's a bum. And by the way, this guy, the day after you pass, is going to be the first person online saying, where's my money? So, it's just one line. I leave nothing to X. Not a dollar, not a reason, nothing. Sometimes, though, we don't leave, it's your right to decide who gets what. More and more people living into their grandkids or great-grandkids. Most people, their own kids, already established, have their own house, but how much have they put away for their kids' college? Certainly not enough, because you don't really realize how much college costs now. I went to this college I love, University of Scranton. I was a runner, so I knew I was only Division III talent and not a Villanova or Georgetown talent. But one year I go to my wife, and I think my kids were in grammar school. He goes, you know what? I like to give University of Scranton, $2,000 this year. She goes, $2,000? How much have you put away for your own kids? Nothing. You're going to give $2,000 to total strangers, and you haven't put away a nickel for your own kids? He goes, well, if you put it that way, I guess Scranton's not getting anything. Or it was not $2,000 anyway. So, but sometimes you might have one child that needs it more than another. So, with a client, she goes, I want 80% to go to this daughter. I'd say, daughter number one married Dr. Rosenberg, the plastic surgeon. Their second home on LBI is worth $5 million. The number two, she did okay also. The third one, the husband was a bum. They got married, and he never paid child support, alimony. She needs it more than the other ones. But you got to make sure. One of the important things a lot of times is, people sometimes want to contest wills if they don't think they're getting what their fair share is, and that's why the other thing the surrogate says: if you have it done by a professional attorney, at least you have independent witnesses that there was only one person in the room when they signed, and they said, okay, did you read it? Does it contain what you want? And show us some ID. What smells is when someone was in the hospital and the one kid prepares it online and goes, sign here. And I've gotten calls where there's will contests, and I'll say, and first thing I ask if they're the executor, who prepared the will when they're getting more. I did it on my dad's request, and Judge Hammond one time had a legal term like BS, that's why, listen, sometimes people can't get out and they'll go and have a notary come to the house, but I at least need to talk to them first, and not where the kid is like fishing them what to say. Okay, tell me, who's it going to be executive 1, executive 2, how do you want your stuff divided, okay? So again, it's your right to do with what you want. Some people have what's called specific bequests. What's a specific bequest? Well, sometimes the ladies say, any jewelry that I wanted to go to my daughter or my granddaughter. Because they know if it's their son will go to Cash for Gold and goes, what do you give me for this junk? Sometimes the men have things that they want to go to, a guy in line in the family. I'd say one of my buddies from my runners club, he had this musket handed down from generation to generation from the French and Indian War. Now, right now it can't be fired. It's 250-year-old hunks of wood and rusty metal. But he goes, listen, to honor my dad, I got to pass it down to the next. So it's going to my nephew. If he wants to toss in a garbage can or donate it to the museum, that's what he can do.
Right.
But remember, your collectibles ain't really worth anything. They're only worth something when you pay good money for them. I mean, if it's gold or Krugerrands are real, but when the people say, oh, my expensive figurines and whatever, someone will say, I want my grandmother's china to go to. I goes, that's a different generation. I think no one wants our china or my mother. You have to hand wash it. I mean, it was real fancy, gold, whatever. But everyone wants to retire to have a couple cocktails, not to be. I was blessed. At least I could put all the stuff on the floor, and the dog would lick everything clean. That's what I did. Okay. If you're leaving any money to grandkids, if they're under 21, you always want to have a clause that says they got to wait till they're 21 or 25, but it can be used for college. Because 19-year-olds buy beer and go to Seaside. Okay? Let's see. For your grandkids that are older, if you already have a will, open up your old will and say, hey, is this still what I want? And only the original will can be admitted to probate. Photocopy can't be admitted to probate. Kind of think of the surrogate as a fancy name for the will clerk. Let's see it.
The will what?
The will clerk. So you have the surrogate needs the original will and a death certificate, check for about $150, and after that they'll give you the papers. Okay, good luck to you. You're the captain of the ship. But it has to be the original. If it's not the original, then the family typically has to go through what's called a complaint order show clause and in the Superior Court, spending thousands of dollars to admit to probate the photocopied will. Where is your original will? Well, it should be a place where your executor can get to it. Don't put it in a safe deposit box. 2 reasons. Can't get to it. Can't get to it, especially, or your power of attorney leave. Can't get to it on a weekend, night, whatever. And what happened in March of 2020? All the banks closed.
Oh, yeah.
So you couldn't get to them. And and a lot of times the banks ain't your friends. My dad's 92. He's still around. And when they were still living up in Edison, he goes, hey, listen, we put you on the safe deposit account. Here's the key. And one day I decided to go to the bank. He goes, because he said my kids' bonds were in there. And I go, I have my ID, I have the key. Now, by that time, the bank had changed from Metuchen Commonwealth to First Fidelity, First Union, Countrywide, then Wells Fargo. Wells Fargo, you're not on the account. No, listen, I'm on the account. If my father, the engineer, says he drove here and it filled up, I know he did. He's not someone getting lost driving a ShopRite. But the problem is, Wells Fargo, when he took it over, never got the paperwork on who was on. So, and then they tried to trick my mom, who was 75 at the time, into buying a 30-year annuity.
Oh, wow.
That's what Wells Fargo's trying to rip people off. Okay, there was another change in the law. The old way of doing wills, the person signed in front of two witnesses. One of the witnesses had to go and sign paperwork in front of a notary saying they were the witness. The new kind of will, what we do, is called the self-proving will. Person signs, there's two witnesses, then you turn a notary, they're signing twice. The witnesses are signing twice with some language. This way, none of the witnesses have to be located ever. If you can't find your original will in the next week, have a new one done. Don't put it off. Okay. Now, get your stuff done if you don't already have it done. Let's see. Don't be a Carl. What is a Carl? Who's a Carl? Carl was this retired engineer type that he came in to see us, and his estate was subject to estate tax at the time. And he kept on saying, well, I'd like to read more up on this. Carl, you don't need to read anything on it. I read for you. I went to law school. I passed the bar. I wrote a book on this. I go, when I need a knee surgery, I don't read about knee surgery. Doctor, can you do it? Yeah, okay, good. I'm happy. I want to read up on it. 2 years later, the daughter calls. Oh, my dad passed. Do I have his will? No, we want to read up on stuff. He was one of those kind of guys that, when he got the new car, he read the whole book from cover to cover. Now there's someone at AAA that's read the book for me, or Ford Motor Credit. So let's see. That's all you really need to know a little bit about wills. Now, one thing I will say is I mentioned only have an executor one. You don't need to read anything. And the other kind of thing is there are certain assets that don't pass under your, even if you have the best will that was ever done. Let's see, they don't pass. They go directly to your survivor. Are you with me? So, if a house is owned husband and wife, automatically goes survivor. If you have bank accounts where you put one of your kids down for convenience, they automatically get the whole thing. So sometimes someone goes, I put my one kid on it because they're the one that helps me with my banking, but I know my daughter will do the right thing. I goes, well, of course you do the right thing while you're alive. But your hope is that they do the right thing later on. So the big accounts, it's better you can put all three, but that doesn't dispense with having the will. So a will can't change who your beneficiaries are on your life insurance, any other policy, whichever the beneficiary gets it. Okay. Does anyone have any easy questions on wills before I talk about the power of attorney?
Yes.
Excellent.
I have a trust and I want to add a codicil. What's the procedure?
Well, is it a trust or a will?
It's a trust.
Okay, so let's talk about trusts, okay? Let's see. Do you own property in any other state?
Yes.
Where?
Florida.
Exactly. Now, okay, that's we get a call all the time. I want to set up a trust, and I go, okay. New Jersey's the probate easiest state. Why do you want to? If you only have assets in New Jersey, why do you want to spend between $3,000 and $6,000 on setting up a revocable trust? On the other hand, Florida, New York, California are the worst states. So if you don't have your assets owned by a trust in those states, you're screwing your family. Let's see. My wife's father, was living in Florida, had a condo, and 15 different times they said, listen, JB, you should have your condo owned by a trust. Nobody tells me what, World War II vet, parents from Ukraine. Nobody tells me what to do. Okay. But so, Now, with a trust, you're not owning the property anymore. Okay? It's owned by the trust. So you have to, any assets you want to have owned by the trust, you have to have a new deed done if it's real estate, if it's accounts. Typically, now the question was, how do I change things in the trust? There's usually a clause in a revocable trust that says the trustee, if it's the grantor, can make whatever changes they want, as long as, during their lifetime. So so sometimes I tell people, look to see, was it prepared in New Jersey or whatever state? It was prepared in another state. Ask that person who prepared it, because they already have the forms, and again, it kind of saves you money. If it was done in New Jersey, kind of look at it, but go to the person that did it, because they usually charge a big chunk of money. Having a will done usually costs, $500, $600 a piece. These trusts usually cost, between $3,000, $6,000, $7,000 for a revocable trust. So when people in New Jersey say, why do you think, no, my mother-in-law used to call me every other year. I want to come in and get a trust done. It wasn't going to cost her 2 cents. But I would say, we were watching Susie Orman on TV. And she says, oh yes, Susie Orman is exactly right if you live in New York, California, Florida, where it's very complicated. And I say to people now in New Jersey, by the way, Susie Orman sells trusts. I mean, she has a company that sells trusts. I recommend you have a trust, and I recommend you have my company do it for you. I can't recommend my company, but we have a company that does it.
Who owns the trust?
So, yes, sir.
Who owns the trust?
Well, typically you have someone who's the trustee. And it can be on a revocable trust, it's you. And then there's usually, it says, okay, upon my passing, this is what happens. Most people don't need to have something that's going to extend on for 80 years. It's usually during their lifetime in Florida where it says, to avoid probate. But in New Jersey, because probate is so easy and streamlined, I tell people, listen, I love making money. I want people to come in every day to say, I want to spend $6,000 setting up fancy trusts. But when my parents and the Sisters of Mercy were smacking me in the back of the head in grammar school, trying to teach me right from wrong, it was about doing right. And I read this book when I was it was called Building the $1 Million Estate Planning Practice. But it was about trying to get people to spend $6,000 on something that they don't need. And I wouldn't be comfortable trying to sell something like my best man's mom on something that she really didn't need. That's why I asked people, what do you think you need a trust? And you can't tell me because your friend who lives in Florida. Now, if you own real estate in another state, revocable trust is the way to go with that property in that state. But if the only thing you got is stuff in New Jersey, just keep it here.
If it's not a revocable trust, can that be changed?
Yeah, revocable trust, it can be changed, whatever, because that's why it's called revocable.
But if it's not a revocable...
Now, there's a thing called the irrevocable trust. Can never, ever, ever be changed unless there's some kind of technicality to get a Superior Court judge to invalidate it.
What about if one of the recipients died? Would that money go then to the children or the wife?
Typically you have a clause that says, similar to a will, your will should say it goes to whomever. If they pass, who gets their share? If they don't have children, who gets, it should have a kind of a trickle down where who gets stuff. Now, every other week we get a call. I want to get an irrevocable trust done. That's where you're trying to shield assets from nursing home, Medicaid, etc. Okay? I say the attorneys that do that are going to charge $12,000, $15,000. If you don't want to spend the money, you save money on their console fee, because they usually charge a $400, $500 console fee. But some people are so concerned that and it's a 5-year look back anyway. But some people were so concerned, I'm willing to spend the money because in case I go into a nursing home, and that's how much it costs for 1 month of nursing home anyway. Someone did ask me, and this actually, it was a daughter that brought her mom in for planning. but I could really tell it was she wanted to protect her inheritance. Let's see. And then the daughter, they said, well, what did I do? I goes, did I put my money into an irrevocable trust? I goes, no, I'm not going to trust my kids to take care of me. If you give away all your money, then you can be sent to the welfare nursing. You go to the welfare nursing home.
I have a question
Yeah.
then. So a revocable trust, when a person passes away, that means anything they owe gets paid off by the trust before it gets to the family?
Everything, under all the laws, debts and taxes get paid first.
Gotcha.
But here's something interesting.
So an irrevocable means they can't touch that money.
Can't
It's
touch-
going.
Now, some
Gotcha.
people say, you know what? I'm not really comfortable with giving away everything. Okay. So some people, though, within their will, they say sometimes some people have a kid that ain't. I'll use a nice word. Ain't good with money. Okay. They could have substance abuse problems, alcohol problems. So we're involved with an estate where there was 4 kids, but for one of the kids, everything was like, instead of it going to that kid with the alcohol problem, the oldest sister was the trustee and was using his share of the money to pay for his rent, pay his car insurance, and buy him ShopRite gift cards so he couldn't buy booze.
Right.
Okay? And so his ex-wife brought an action in Superior Court to ask the judge to compel the trust to pay her money that's owed. I go, in front of the judge. This case law, the statute is clear. The reason, the money that's in this testamentary trust is in the sole discretion of the trustee. They don't, so it can't even be taxed by tax. It's the only thing that can't be even taken by the tax person or Medicaid. They go to the nursing home, trustee can say, I'm not paying. So the judge says, hey, Mr. Vercammen, you're right. That's the law of the law. Now, but going back, the person asked me, what did I do? I goes, I want to go to the most expensive nursing home that exists. If I am that sick that I can't stand up and wash myself for the last weeks or months, whatever, I want to get better care rather than crappy care. I mean, that's me. Hey, I'm the one who worked hard. Let's see, some of you young guys at the end, do you remember working hard when you were 13, 14 years old? Because you didn't have any money. So I remember when I was delivering newspapers in the rain on Sunday morning in December, I'd say, you remember how the newspaper was this thick. I'd say, bikes pedaling by, and I'd get like a dime from each house a week or something like that. It wasn't so that my son, Dr. Brenda, could have a bigger boat, in a crappy nursing home, so that I have some money down the road. At least that's me. Okay. The next thing we're going to talk about is, oh, by the way, once your will is done, a will is good forever unless you want to have it changed. Okay? Just don't lose the original. We do recommend that people do a new power of attorney, though, every 5 years. The law says a will is good forever, but there's no statute that says how long a power of attorney is good for. Okay. What is a power of attorney? What's that? Okay, so an assets take care of your, a will takes care of your assets while you're alive, and etc. What a power of attorney is you're giving the power to someone you trust to be able to help you out financially and legally. So just because someone's married, the spouse got zero power to do anything, let's say legally. If driving home, later and some dumbass kid who's looking at their phone and T-bones my car and my arm breaks and I can't sign anything, I have a power of attorney. My wife can sign for me. All right. A power of attorney is either effective right away or only upon disability. When it's effective right away, that's called a durable power of attorney and stays into effect even if someone becomes disabled. If it's effective only upon disability, that's called a springing power of attorney, only springs into effect if someone becomes disabled. and there's written documentation from a doctor. Let's see, one of our clients, he was a carpenter, and he was like, Kenny, I don't understand, I'm a carpenter, I only know hammers and chisel. He goes, explain to me in carpenter language, I don't understand legal stuff. I goes, okay, you put your son as your number one agent. Okay, if it's effective right away, he can steal all your money right away. And go to Cuba where it's warm. If it's effective only upon disability, he needs to get a note from a doctor before he steals your money and goes to Cuba. Knowing that, you trust your son. He goes, I trust my son my life. Good. Make it effective right away. Let's say, I mean, your son's not going to steal it. Let's see, some of the banks were giving people a hard time with something, with some of the powers of attorney. So New Jersey legislature came down with a statute that says if it's a banking institution in New Jersey, they make and references to New Jersey statute, they have to honor it. However, it has to make reference to Section 2 of PL 1991, C 46:2B-11, and the cheap stuff online doesn't mention that, so it's not going to be valid. We also recommend that after you sign your power of attorney, give a copy to if you have an accountant or financial advisor person. That way, if your kids need to help you, they are already familiar with who that. I was the power of attorney for one of my Edison neighbors. They had no kids, and I was power of attorney number 2. Husband goes to the hospital first, and the wife goes to the hospital. We need to get the bills paid, and at least the hospital number 2 says, hey, she can't sign anything. She's in the wing where people need help. So I was able to do that, but that's why, now, also, I don't know, if you're not treating everyone equally, don't leave the will in your house. Okay? Because, or in your hospital, because sometimes the person that wasn't really involved, let's see, goes rifling through their house looking for stuff. And all of a sudden they find a way, goes, son of a bitch, I'm only getting 20%. Well,
Yeah,
now I'm getting half.
Doesn't the lawyer have a copy then?
What good's a copy? A copy is what good's a copy. Now, you'd have to go through that procedure there. So if it's not all equal, you're better off letting the person who's number 1, your executive number 1, hold it in there, and they're safekeeping.
And if executive number 1 can't hold it, then number 2 takes over? Or
If
do they work jointly?
if the executive number 1 passes, or they could resign, or if they're in a loony bin, then you could get an order from the court saying number 2's up now. All right. Okay, Bella, how much time I got?
I mean,
Oh no, you gotta go like this. I don't see it. Okay, my 30 minutes is up. I got 15 seconds to talk about living wills. Okay. Lastly, living wills is a document where let's say you're giving instructions to hospitals and doctors. If you can no longer talk, you're in a terminal condition, coma, whatever. It's typically you don't want, to be kept alive for long periods of time. Let's see. So it's not really a document for you; it's for your family, so that they're not bickering or wondering what to do. Because without it, then you put your family into the ringer, so that they have to suffer and decide what to do. And I remember one time there was someone where the doctor said, I was the person's power of attorney because she had no kids, her spouse was passed. I was her power of attorney, but she didn't do a living will. Doctor calls, it's the last week or whatever. Do you want us to remove life support now? He goes, geez, doctor, I feel bad. I mean, the right decision for someone that's 92 years old that's not going to open up their eyes again, but you hate to be the one to say, yeah, go ahead and do it. I mean, I couldn't even do it for my first dog. I had to have my wife go in. So the idea is getting it done, and that way it's there. Plus, you're picking someone to be able to talk to doctors and make decisions, and it's also to prevent the person that wasn't involved and wasn't the helpful one from barging into the room to say, hey, I'm in charge now, and this is what we're going to do.
Right.
And the answer is, you're not in charge, and you're lucky that we even let you in the room. So anyway.
So the person, in the living will, there's a person who's like an executor
it's usually
that
the
can
same-
make
it's
the
usually the same
decisions.
person. So there, in the will it's called the executor, the power of attorney it's called the agent, and the living will is called the agent, but kind of the same person.
Gotcha.
All right. So my name is Ken Vercammen. Let's see, my office is in Edison. The office phone number is 732-572-0500. And I thank everyone for listening today. Thank you.